I looked down the street, most directions. It was getting dark, getting cold, and I got in the van and I hit a bunch of corners. I went down this street. I turned my light on. I searched. I called their names. Talked to a gentleman on the street on the other side over there. He didn't see anyone.
So he left at 16:33 and he's back by 16:38.
How fast he's coming back? He's punching it, bro.
Yeah, he's moving.
Look at that.
For people who are thinking that there's some kind of foul play involved, we just spoke to the biological mother. She says she had a conversation with you guys, and that she thinks there's some kind of foul play involved. That she thinks you guys did something.
And that's understandable.
What's your response to that?
That's understandable. I would think the same thing.
Yep.
The community is scared, confused, and angry, and so is the biological mother of both boys.
I don't understand.
Where are they?
Ultimately, the answer to the question of where are the boys will be answered. It's that they're dead. And at the end of the case, I will ask you to return a verdict of guilty beyond a reasonable doubt as to Trezell and Jacqueline for the murders of Orrin and Orson West.
A grand jury indicted the West, the adopted parents of Orrin and Orson, in March 2022. Their attorneys have said the couple had nothing to do with the boys' disappearance. The bodies of Orrin and Orson have not been found. The trial of Trezell and Jacqueline West is back in session. The West are charged with crimes including murder in the deaths of Orrin 4 and Orson 3, also known as Classic and Sincere, and the trial is now in its 20th day. It is expected to wrap up soon. Judge Charles Brimmer told the jury that a couple of days ago there was an objection to a motion to strike regarding a witness, and he struck testimony related to initial contact with children and county counsel. Alexia Torres-Stallings, lead counsel for Jacqueline West, has called Dr. Susan Napolitano to the stand. She is an expert witness who the defense will use in an attempt to show the testimony of the West's eldest child was influenced by interviewers and isn't reliable. Napolitano is a clinical and forensic psychologist. Her clinical practice involves helping people through her private practice. Her forensic practice is the place where my psychological knowledge intersects with the law. She provides answers to complex legal questions regarding child forensic interviews. Napolitano is going over her education and qualifications. The youngest child Napolitano has evaluated is 18 months, and she has treated children as young as 2 or 3 who have experienced trauma. Napolitano testified she has been part of FBI investigations where they relied on her. She also worked with other agencies and has interviewed children regarding allegations of abuse. Napolitano said she's testified about 150 times in criminal, civil, and federal courts. She has at times been appointed by the court. When it comes to criminal matters, she testifies about 50% of the time for the prosecution, the other 50% of the time for the defense. Napolitano testified yesterday was the first time she met Trezell and Jacqueline West. She said sometimes she avoids getting to know the parties in a case to avoid bias. She has not met the West 4 other children. She primarily was asked to look at forensic interviews of the children, Napolitano said. She has been examining this case for about a year, Napolitano said. She charges $350 an hour for forensic work and was approved for 100 hours of work on this case. Napolitano said she has reviewed police reports that were summaries of the first forensic interviews and one related to Wanda West, Trezell's mother. She has watched interviews of the West children and looked at the transcripts and CPS summaries. Napolitano testified she listened to parts of the testimony of the boys at the trial. She has prepared a PowerPoint to assist her testimony today. A child forensic interview flows from specific training, the most appropriate way to question a child to make sure the interviewer's beliefs don't influence the child. There are a number of protocols that have been together. A list of do's and don'ts, Napolitano said. The goal of a forensic interviewer is to prevent a false conviction or acquittal in child abuse cases based on the interview with the child. Napolitano is going over old cases. Prior to 1975, there was a mentality of what happens in your home is your own business, she said. After 1975, that changed. There was an ideological swing to protect people in the home. There were some waves of hysteria that took place in the 1980s and the 1990s, she said. People began suspecting satanic child abuse rings, including Bakersfield's own Stahl case, where children were overzealously questioned to put people in prison. Large numbers of people were convicted on child interviews alone, Napolitano said. When later examined, the evidence was found to be flimsy, she said. These cases led to changes in how children were questioned. The forensic psychology field developed as a result. As a result of cases, there were recommendations for more systematic protocol of how to question children when abuse allegations were involved, Napolitano said. How to question children has been fine-tuned over the decades based on research from forensic interviews and other social studies where we have learned about the suggestibility of children, Napolitano said. One study dealt with misinformation. Children were playing Simon Says and were asked to touch their stomach and another child's nose. 1 month later, social workers interviewed the children, and half of the social workers knew nothing about the study. The other half were told the children may have been asked to touch a child's toe. On that side, a decent amount recalled they were asked to touch someone's toe. Touching a toe never happened, but the children said it did based on the question. Another study had to do with false memories. Adults were asked about 4 memories from their childhood. 3 of the events took place, as told by researchers by the family. They also confirmed the adult had never been lost in the mall as a child. The interviewer then asked the adults about the time they were lost in the mall as a child, and 25% believed it happened. Cognitive dissonance is when a person is given 2 pieces of information that conflict, and the person tries to fill in the blanks to make it make sense, Napolitano said. This cognitive dissonance led 25% of the adults to create memories of being lost in the mall as a child because the interviewer's question indicated it had happened, she said. It is now standard practice for police to record child interviews for examination. The earlier cases influenced how children are questioned with the focus on their capacity for suggestibility. It is common that before a child gets a forensic interviewer, somebody untrained has talked to them, Napolitano said. She said there are pitfalls to that. She said it's important to get to the professionally conducted forensic interview as soon as possible after the allegation is made. Napolitano said suggestive questioning, when you ask a question of a child and give the answer to the question in the question, was found to be a major issue. If you show interview bias early in the interview, it's much more likely the child will agree with your mindset, Napolitano said. This contained the child's answers, she said. Confirmation bias. It's when we look for information that confirms our beliefs. When this happens, everything you see is filtered through that lens, said one of Napolitano's PowerPoint slides. As a hypothetical, Tori Stallings asked if an example of confirmation bias would be if law enforcement had decided a child was never in a house and stuck to that belief despite later finding diapers and toys in the house. Napolitano said yes. This bias can be found in interviews, Napolitano said. Napolitano said more than one plausible hypothesis must be considered to answer a forensic question. In this case, there are 2 prevailing hypotheses. Someone abducted the children, or the West are responsible for the missing children. She said she would have expected to see those hypotheses examined in the forensic interviews in this case. Napolitano has conducted at least 100 child forensic interviews and has reviewed hundreds that were conducted by others. She said it's not common to have more than 1 forensic interview on a single child. I don't recall seeing that in my career, she said when asked if 2 or 3 would be extremely rare. Napolitano said she knows from these studies that a child's statement can be contaminated if questioned repeatedly. Children should be placed in a kid-friendly room and questioned by a person not in a uniform, not wearing a gun. It's friendly and has qualities children will find non-threatening, Napolitano said. A child's cognitive abilities must be taken into consideration, she said. Get them to talk in an open-ended way about something, even what they had for breakfast, and get a sense of their cognitive and language abilities. Asked about recall, Napolitano said it's a certain type of memory when someone asks a question and you just recall the answer. She said it's considered by her profession to be the most accurate report. Recognition, in contrast, doesn't pull so much from memory. It's a response to a sensory cue to see if you recognize it. These responses are less accurate. Tori Stallings is going over interview phases with Napolitano. Rapport building, interview instructions, truth versus lie, narrative practice, substantive phase, narrative and detail gathering, alternative hypotheses, and closure. A forensic interviewer should question an alternate hypothesis in a non-leading way to get to the truth, Napolitano said. Court is in recess for 15 minutes. Court is back in session with Napolitano still on the stand, being questioned by Tori Stallings. Napolitano said questions with a child should be open-ended, not yes or no, or multiple choice questions. Examples of improper questions would be leading, suggestive, coercive, repeated, or social pressure questions. Napolitano, in regards to the eldest child's interview by Cal City police officer Brian Hansen, found some things highly atypical, particularly when Hansen asked if the boy knew killing someone or assisting in the killing of someone was wrong. Tori Stallings is playing the first interview. After watching a portion, Napolitano said the questions about hurting or killing someone would prime a child into thinking someone had been hurt or killed, and placed in his mind that something had happened to Orrin or Orson. Napolitano said an interviewer must be clear about what they're talking about when questioning children. Be specific. Don't say they or them. Give the exact names. Going over the interview, Napolitano notes, as Tori Stallings called it, there are no anchors in time. The officer doesn't give a specific date regarding his questions about when the boys were dropped off, for example. Regarding the interviews conducted by social worker Sonia Barton, Napolitano said she did a lot right in the questions she asked and follow-up questions. She said Barton has clearly been trained as a forensic interviewer. I thought she did a lot right, Napolitano said. Reviewing a portion of one of Barton's interviews with the eldest child, Napolitano confirmed there were multiple repeated questions and peer pressure questions where Barton told the boy what his older brothers had said. Napolitano said Barton would not accept the boy's answer and used inappropriate techniques and questions. She described one segment as extremely leading. Tori Stallings is playing another portion of the video. After watching this segment, Napolitano said there were some questions that should not be asked. She said there was a great deal of social pressure on this child during this interview. She said Barton told the boy, "Your brother said," and similar statements, letting him know what his brothers had told her and possibly influencing him. There was also implementation of ideas and dramatic, scary words like "spank till you bleed" in the segment, Napolitano said. She said that portion of the interview was poorly done by Barton. Another interview segment is being played. In this segment, Napolitano said the eldest child is being asked a question over and over again to conform to what his other brothers had said, and she says she hears skepticism in Barton's voice. One question by Barton goes along the lines of, "What will it take for you to speak up?" which Napolitano said falls under the label of a coercive and suggestive question. Regarding Barton's testimony yesterday, Napolitano said the documentation that indicated she believed the eldest child was lying indicates she had a preconceived notion and bias before the boy was questioned on December 28, 2020. The eldest child never says Orrin died until Barton asks something about Orrin's body which, in Napolitano's opinion, led the eldest child to think about seeing him dead. It could be a reconstruction of an event that never happened. In the eldest child's second interview with Barton, there was a discussion of smell. Barton brought it up. There had been no mention of it before. Barton bringing it up is a leading question, but what caught Napolitano's attention is she tells the boy he mentioned it before. Napolitano said it appeared to her the boy was guessing as to what Barton meant. Court is in recess until 1:30 p.m. The trial of Trezell and Jacqueline West is back in session, and Dr. Susan Napolitano is back on the stand testifying to her opinion of interviews a social worker conducted with the West's eldest children. Napolitano, a licensed clinical and forensic psychologist, has been called as an expert witness by the defense. Alexia Torres-Stallings, lead attorney for Jacqueline West, is asking Napolitano questions about the eldest West children's grand jury testimony. There have been multiple objections by the prosecution. A sidebar has been called. Sidebar is over, and Torres-Stallings is continuing to ask about questioning during the grand jury testimony and what Napolitano thinks of it. Napolitano said the boy gives a statement that is not consistent with his previous statements, making her question why there is the inconsistency and how to get to the bottom of it. Napolitano said she found it significant the eldest child, at the start of his testimony before the grand jury and at the trial, said he didn't remember or said his brothers were with him. Napolitano said she didn't know the 4 eldest West children had a welfare check on December 21st, 2020, the night Orrin and Orson were reported missing. She said that may have had an impact on the children. Napolitano said if she sees a series of interviews in which children say a number of inconsistent things, she doesn't know which one of those statements to believe. Another sidebar has been called. They're back, and Torres-Stallings has resumed questioning. Given a hypothetical, which follows the series of interviews performed with the children in the West case, Napolitano said she finds a lot wrong with it and potential for error. Torres-Stallings is asking about restraint techniques for children, and there was an objection as to the question's relevance. The objection was sustained, and that line of questioning has ended. Napolitano said her hourly rate of $350 is customary among her peers. She said the county is paying her fees. Torres-Stallings has ended her questioning, and prosecutor Eric Smith has begun cross-examination. Smith is asking about the difference between a psychiatrist and psychologist and the current focus of her practice. Napolitano said she works on child custody evaluations, evaluates sexually violent predators. She said she reviews 5 to 10 child forensic interviews a year. The last time she conducted a child forensic interview was in 2006. So it's been 17 years since you personally did one? Smith asked. I guess time's gone by fast. Yes, it's been 17 years, she said. Asked the last time she testified for the prosecution, Napolitano said she couldn't recall an estates case, but she testified for the U.S. Attorney's Office in the last 3 years. Smith asked, who pays better, the prosecution or defense? Napolitano said it depends. She could get paid quite a bit more if hired by a private attorney than through a state office, Napolitano said. Napolitano confirmed she will be paid $35,000 to $42,000 for the work she's done on this case during the past year. Smith asked her what work she's done on the case. Napolitano said she reviewed interviews by Hansen and Barton with the children and reviewed grand jury testimony and other transcripts. She said that took her 100 hours. Asked her for her notes, Napolitano said she wasn't aware they had been requested. Smith asked if she was aware he didn't get her PowerPoint slides until yesterday. She said she's certain he got an earlier version. Napolitano said she didn't write a report about what she reviewed and did because she wasn't asked. Napolitano testified she didn't review the 2,000-page offense report in this case. Asked by Smith to describe what she has generated in this case, She said she's taken notes on the transcripts and wrote up for her own purposes what she found problematic. Napolitano testified she's never been asked for the notes until now. Smith has formally asked for them on the record. She said she can get them to him, but not at this moment. Tori Stallings asked for a sidebar, but Judge Charles R. Brimmer has denied it until the mid-afternoon break. Asked if money could result in confirmation bias, Napolitano said if you're getting paid for a specific opinion, it could bias you to agree with that opinion. Smith has referred to a report where another doctor criticized Napolitano, saying she exhibited bias favoring her client without sufficient data to back up her opinion. Napolitano said she's aware of the report. Napolitano doesn't recall being accused of cutting and pasting her presentation in the case from other cases. Napolitano confirmed she has not been present throughout the entire trial and has not reviewed other evidence in the case, just child interviews. Smith ended his questioning, and a 15 to 20 minute break has been called. Court is back in session. Napolitano remains on the stand, and Timothy Hennessy, lead attorney for Trezell West, is questioning her. Napolitano said there are cases she declines. Napolitano said this is one of the few cases where her fee was accepted in a public defender type arrangement. Napolitano said children can make false statements without intending to lie, and Hennessy ended his questioning. She has been excused. Tori Stallings requested a brief sidebar. They're back, and the defense has no other witnesses. The defense has rested, and evidence in this case has concluded. The judge said the jury will return at 2 p.m. for a few additional items or clarifications, and then they will receive jury instructions. They were reminded not to begin deliberations until after closing arguments, which are expected to begin next week. The bottom line is that the prosecutors in any case, whether it be a misdemeanor or a felony, have to prove their case beyond a reasonable doubt. Now, trying to figure out exactly what that means is not always easy. There's a jury instruction. It basically says, the judge tells the jury, I will now explain the presumption of innocence and the people's burden of proof. The defendant has pleaded not guilty to the charges. The fact that a criminal charge has been filed against the defendant is not evidence that a crime is true. You must not be biased against the defendant just because he or she has been arrested, charged with a crime, or brought to trial. This is the start of the explanation of beyond a reasonable doubt, because it talks about that when the trial starts, a defendant has a presumption of innocence, meaning that they're presumed innocent. So if the jury had to vote right then, they'd have to vote not guilty. Burden of proof. It also says the people have the burden of proof. That means whoever is prosecuting the case, whether they be the district attorney, the city attorney, in a federal case, the assistant United States attorney, they must prove the case. And if they don't prove the case, then there's not any type of guilty verdict. Because if they haven't proved all of the elements of what they've charged the client with, it's not a guilty verdict. Just because somebody is charged doesn't mean they're guilty. Just because somebody is charged, you shouldn't be looking at the person in a negative light. You should keep an open mind, listen to the evidence, and if the prosecutors can't prove their case, then you should find the defendant not guilty. Presumption of innocence. The instruction goes on by the judge to the jury, and it says, a defendant in a criminal case is presumed to be innocent. This presumption requires that the people prove a defendant guilty beyond a reasonable doubt. This is where it starts to become very nebulous and confusing because they just keep mentioning the term reasonable doubt over and over again. I think what it really boils down to is a jury is going to listen to the evidence, and if they don't feel that this person should be convicted of this particular crime, they're going to find him not guilty. There are some other terms that they use, but they just keep saying beyond a reasonable doubt and presumption of innocence over and over again, thinking somehow that's going to explain exactly what the standard is and what the prosecutors have to prove and to what degree do they have to prove it. Proof beyond a reasonable doubt. So the instruction goes on. Proof beyond a reasonable doubt is proof that leaves you with an abiding conviction that the charge is true. The evidence need not eliminate all possible doubt because everything in life is open to some possible or imaginary doubt. So they go back and forth. One side for the defense, one side for the prosecution. When they look back 10 years from now, they're going to have to say, okay, I feel confident that the person is guilty if that's their finding. But if they can't do that, if they're not sure, if they don't think the prosecution has put all the evidence on, then it's not a guilty verdict, period. They should do that very quickly and very easily because of the presumption of innocence. The last thing the judge reads to the jury in a criminal case when they're talking about the whole concept of beyond a reasonable doubt is in deciding whether the people have proved their case beyond a reasonable doubt, you must impartially compare and consider all of the evidence that was received throughout the entire trial. Unless the evidence proves the defendant guilty beyond a reasonable doubt, they are entitled to an acquittal, and you must find them not guilty. And as confusing as that may all still be, the people are just going to have to listen to the evidence, get a feel for it, and then make an informed decision about whether or not the prosecutors have brought enough evidence so they feel comfortable finding the defendant guilty. Or if they feel the defense has put on a very strong argument, they feel confident finding the defendant not guilty. If the verdict is guilty, the judge determines the defendant's sentence. If a defendant is found not guilty, the defendant is released and the government may not appeal. The person may not be charged again for the same offense in a federal court. The Constitution prohibits double jeopardy or being tried twice for the same offense. Just wanted you guys to know where we are in this thing, where we really are in this thing legally.